CPP pilot program. 4, approval of revised depreciation rates applicable to electric and common plant in service. 5, approval of necessary and appropriate accounting relief, including authority to capitalize as rate base all cloud computing costs and defer to a regulatory asset amounts not already included in base rates that are incurred for third-party cloud computing arrangements. And 6, approval of an alternative regulatory plan granting CEI South a waiver from 170 IAC 4116F to allow for remote disconnection for non-payment. Notice of the time and place of the hearing was given as provided by law by publication in Marion County in the Indianapolis Star on March 6th, 2024, and in Vanderburgh County in the Courier and Press on March 7th, 2024. These are newspapers of general circulation, and these publications were made at least 10 days prior to the date of this evidentiary hearing. The proofs of publication of the notices have been received by the Commission and are now incorporated into the record of this cause by reference and placed in the official files of the Commission. Notice has also been given to the Indiana Office of Utility Consumer Counselor and other interested parties. May we have appearances, please? And we'll just go down the line from petitioner.
Thank you, Your Honor. On behalf of petitioner, Southern Indiana Gas and Electric Company, doing business as CenterPoint Energy Indiana South, Hillary Close and Nicholas Kyle of the law firm Barnes & Thornburg, LLP, and Heather Watts of CenterPoint Energy.
Thank you, Your Honors. Good afternoon. On behalf of Citizens Action Coalition of Indiana, or CAC, please accept the appearance of Jennifer Washburn.
Thank you, Your Honor. On behalf of the intervener, the Common Council of the City of Evansville, Indiana, please accept the appearance of Ann Becker and Aaron Schmall.
Good afternoon, Your Honor. Appearing on behalf of Sabic Innovative Plastics, Mount Vernon, LLC, Nikki Schultz of the law firm Bose, McKinney & Evans, Indianapolis.
Thank you, Your Honor. On behalf of intervener CenterPoint Industrial Group, Tabitha Balzer and Todd Richardson of the law firm of Lewis & Kappas, PC in Indianapolis.
Good afternoon, Your Honor. Appearing on behalf of the OUCC, Jason Haas and Adam Cashin, representing the public.
Thank you. Ms. Close, you may proceed.
Thank you, Your Honor. At this time, petitioner would propose to offer into evidence the pre-filed testimony and attachments of its witnesses for whom cross-examination has been waived and witnesses who have been excused from attendance at the hearing. And so I will read through that list first. So petitioner would offer what's been marked as Petitioner's Exhibit Number 2, the public direct testimony and attachments of Chrissy M. Bemi. Petitioner's Exhibit Number 2C, the confidential excerpts of Bemi Direct. Petitioner's Exhibit Number 2R, the public rebuttal testimony and attachments of Chrissy M. Bemi. Petitioner's Exhibit Number 2RC, the confidential excerpts from Ms. Bemi's rebuttal. Petitioner's Exhibit 2S, the settlement testimony of Chrissy M. Bemi. Petitioner's Exhibit Number 3, the direct testimony and attachments of Stephanie E. Gray. Petitioner's Exhibit Number 4, the public direct testimony and attachments of Stephen R. Rawlinson. Petitioner's Exhibit Number 4C, the confidential attachments to Mr. Rawlinson's direct. Petitioner's Exhibit Number 4R, the public rebuttal testimony and attachments of Stephen A. Rawlinson. Petitioner Exhibit Number 4RC, the confidential excerpts from Mr. Rawlinson's rebuttal. Petitioner's Exhibit Number 5, the direct testimony of Amy L. Foltz. Petitioner's Exhibit Number 5R, the rebuttal testimony of Amy L. Foltz. Petitioner's Exhibit Number 6, the direct testimony of Greg M. Maurer. Petitioner's Exhibit Number 7, the public direct testimony and attachments of F. Shane Bradford. Petitioner's Exhibit Number 7C, the confidential excerpts, attachments, and work papers from Mr. Bradford's direct. Petitioner's Exhibit Number 7R, the public rebuttal testimony and attachments of Mr. Bradford. Petitioner's Exhibit Number 7RC, the confidential excerpts and attachments from Mr. Bradford's rebuttal. Petitioner's Exhibit Number 8, the public direct testimony and attachments of Ronald W. Barr. Petitioner's Exhibit Number 8C, the confidential excerpts and attachments from Mr. Barr's direct. Petitioner's Exhibit Number 8R, the public rebuttal testimony and attachments of Ronald W. Barr. Petitioner's Exhibit Number 8RC, the confidential attachment to Mr. Barr's rebuttal. Petitioner's Exhibit Number 9, the direct testimony of Christopher G. Wood. Petitioner's Exhibit Number 10, the public direct testimony and attachments of Denicia R. Williford. Petitioner's Exhibit Number 10C, the confidential excerpts and attachments from Ms. Williford's direct. Petitioner's Exhibit Number 10R, the public rebuttal testimony of Denicia R. Williford. Petitioner's Exhibit 10RC, confidential excerpts from Ms. Williford's rebuttal. Petitioner's Exhibit Number 11, the public direct testimony and attachments of Jeffrey T. Kopp. Petitioner's Exhibit Number 11C, the confidential attachments to Mr. Kopp's direct. Petitioner's Exhibit Number 12, the public direct testimony and attachments of John J. Spanos. Petitioner's Exhibit Number 12C, the confidential excerpts from attachments to Mr. Spanos' direct. Petitioner's Exhibit Number 12R, the rebuttal testimony of John J. Spanos. Petitioner's Exhibit Number 13, the direct testimony and attachments of Ann E. Bulkley. Petitioner's Exhibit Number 13R, the rebuttal testimony and attachments of Ann E. Bulkley. Petitioner's Exhibit Number 14, the public direct testimony, attachments, and work papers of Brett A. Gerasa. Petitioner's Exhibit Number 14C, the confidential work papers supporting Mr. Gerasa's direct. Petitioner's Exhibit Number 14R, the rebuttal testimony, attachments, and work papers of Brett A. Gerasa. Petitioner's Exhibit Number 14S, the settlement testimony of Brett A. Gerasa. And Petitioner's Exhibit Number 14SR, the settlement rebuttal testimony of Brett A. Gerasa. Petitioner's Exhibit 15, direct testimony and attachments of Jennifer K. Story. Petitioner's Exhibit Number 15R, the rebuttal testimony of Jennifer K. Story. Petitioner's Exhibit Number 16, the direct testimony and attachments of Michael E. Russo. Petitioner's Exhibit Number 16R, the rebuttal testimony and attachments of Michael E. Russo. Petitioner's Exhibit Number 17, the public direct testimony of Justin L. Forshee. Petitioner's Exhibit Number 17C, confidential excerpts from Mr. Forshee's direct. Petitioner's Exhibit Number 17R, the rebuttal testimony and attachments of Justin L. Forshee. And then I will skip to Petitioner's Exhibit Number 20, which is the Excel financial exhibit. Petitioner's Exhibit Number 20C, the confidential revenue model work paper supporting Petitioner's Exhibit 20. Petitioner's Exhibit Number 20R, the Excel rebuttal financial exhibit. Petitioner's Exhibit 20RC, the confidential revenue model work paper supporting Petitioner's Exhibit 20R. Petitioner's Exhibit 20S, the Excel settlement revenue requirement. Petitioner's Exhibit 20SC, the confidential revenue model work paper supporting Exhibit 20S. Petitioner's Exhibit Number 21, the PDF or hard copy of the financial exhibit. Petitioner's Exhibit Number 21R, the rebuttal financial exhibit in PDF. And Petitioner's Exhibit 21S, the settlement revenue requirement in hard copy or PDF. Petitioner's Exhibit Number 22R, the rebuttal testimony and attachments of Jason A. Cunningham. Petitioner's Exhibit Number 23, the public response to the IURC's April 29, 2024 docket entry with attachments. Petitioner's Exhibit 23C, the confidential responses and attachments to the IURC's April 29, 2024 docket entry. Petitioner's Exhibit 24, the response to the IURC's August 28, 2024 docket entry. And Your Honor, I can also offer at this time the settling parties joint Exhibit 1, which is the stipulation and settlement agreement among the settling parties in this cause.
Any objections from anyone?
No, Your Honor.
No, Your Honor.
No objection.
No, Your Honor.
No objection.
All right, hearing no objection, the following exhibits of petitioners are now admitted into the record of this cause. 2, 2C, 2R, 2RC, 2S, 3, 4, 4C, 4R, 4RC, 5, 5R, 6, 7, 7C, 7R, 7RC, 8, 8C, 8R, 8RC, 9, 10, 10C, 10R, 10RC, 11, 11C, 12, 12C, 12R, 13, 13R, 14, 14C, 14R, 14S, 14SR, 15, 15R, 16, 16R, 17, 17C, 17R, 20, 20C, 20R, 20RC, 20S, 20SC, 21, 21R, 21S, 22R, 23, 23C, and 24, and the settling parties joint exhibit number 1. And then those exhibits are admitted into the record of this cause. And with that, I'll turn it over to Ms. Close again.
Thank you, Your Honor. Petitioner also has a stipulated cross-examination exhibit. I didn't know if Your Honor was planning to offer to the rest of the parties to offer their pre-filed evidence for any witnesses who are not going to be in attendance at the hearing first, and I can offer that cross-exhibit now, or we can wait.
Let's go off the record for a second. Is that okay with everyone to go ahead and do your exhibits now? Okay. Do I have, I guess, I know you have CAC. I've got a list here. Did anyone else, no one else gave us a full list like this, right? You have one. Okay. Okay. Okay.
Your Honor.
Oh, yes.
Your Honor, we also have cross exhibits that the center point is stipulated to the admission.
Okay.
So
we'll start with your stipulated exhibit, and then we'll just go down the line. Does that make sense? Okay. All right. Let's go back on the record. Okay, Ms. Close.
Thank you, Your Honor. At this time, petitioner would also offer what has been marked as petitioner's cross-examination Exhibit 1. The stipulated exhibit is in lieu of cross-examination of certain OUCC witnesses, and it is the OUCC's supplemental response to CEI South's docket and, data request number 8.
Any objections?
No, Your Honor.
No, Your Honor.
No objection.
No, Your Honor.
no objection.
All right, hearing no objection, petitioner's cross-examination Exhibit 1 is now admitted into the record of this cause. Yes, Ms. Washburn.
Thank you, Your Honor. At this time, CAC would move into the record what's been marked as CAC Exhibit 1, direct testimony and attachments of Kerwin Olson, CAC Exhibit 2, direct testimony and attachments of Benjamin Inskeep, which includes a disk with 2 public Excel attachments, CAC Exhibit 2C, the confidential pages of direct testimony of Mr. Inskeep, CAC Exhibit 3, direct testimony and attachments of Justin Barnes, inclusive of revised redaction filed March 22nd, and also a disk with a public Excel attachment. CAC Exhibit 3, highly confidential. These are the highly confidential pages of direct testimony of Mr. Barnes, with also a disk of 2 highly confidential Excel attachments. CAC Exhibit 4, the cross-answering testimony of Benjamin Inskeep. CAC Exhibit 4C, the confidential pages of cross-answering testimony of Mr. Inskeep. CAC Exhibit 5, cross-answering testimony of Justin Barnes. CAC Exhibit 5C, the confidential pages of cross-answering testimony of Mr. Barnes. CAC Exhibit 5, highly confidential, the highly confidential pages of cross-answering testimony of Mr. Barnes. CAC Exhibit 6, testimony in opposition to settlement of Benjamin Inskeep, inclusive of corrections filed July 23rd. CAC Exhibit 6, highly confidential, the highly confidential pages of testimony in opposition to settlement of Mr. Inskeep. CAC Exhibit 7, the testimony in opposition to settlement of Justin Barnes. CAC Exhibit 8, which is a disk of CAC's public work papers. CAC Exhibit 8C, which is a disk of CAC's confidential work papers. And CAC Exhibit 8, highly confidential, which is a disk of CAC's highly confidential work papers. CAC would also move into the record at this time what's been marked as CAC CX1, which is a CAC and Centerpoint stipulation of evidence in lieu of cross-examination of Centerpoint witness 4C, which is the set of responses from Centerpoint to CAC data request set 10, and CAC cross exhibit 2, which is a stipulation between CAC and industrial group of facts and evidence in lieu of cross-examination of industrial group witness York.
Any objection?
No objection.
No objection, Your Honor.
No objection.
No objection, Your Honor.
No objection.
Hearing no objection, the CAC's exhibits, the following exhibits are now admitted into the record of this cause. CAC's exhibits 1, 2, 2C, 3, 3 highly confidential, 4, 4C, 5, 5C, 5 highly confidential, 6, 6 highly confidential, 7, 8, 8C, 8 highly confidential, and cross-examination exhibits 1 and 2.
Thank you, Your Honor.
Thank you, Your Honor. At this time, the Common Council of the City of Evansville, Indiana, would like to move into the record Common Council's Exhibit 1 with attachment, which consists of the verified direct testimony of Zachary Hieronymus, which was originally pre-filed March 12th, 2024.
Any objections from?
No objection.
No objection.
No objection.
No objection.
No objection.
Hearing no objection, the Common Council of Evansville's Exhibit 1 is now admitted into the record of this cause. Schultz.
Your Honor, at this time, Sabic Innovative Plastics Mount Vernon LLC will offer into evidence what's been marked as Exhibit 1, the public testimony of Kyra Coyle, Exhibit 1C, the confidential testimony of Kyra Coyle, Exhibit 1HC, the highly confidential testimony of Kyra Coyle, and Exhibit 1SR, the settlement rebuttal testimony of Kyra Coyle.
Any objections?
No objection.
No objection.
No objection.
No objection.
No objection.
Hearing no objection, SABIC's Exhibits 1, 1C, 1HC, and 1SR are now admitted into the record of this cause.
Thank you, Your Honor.
Ms. Balzer.
Thank you, Your Honor. At this time, the industrial group would offer into the record IG Exhibit 1, which is the direct testimony of Michael P. Gorman, IG Exhibit 1C, which are the confidential pages of the direct testimony of Michael P. Gorman, IG Exhibit 2, which is the direct testimony of Jessica York, IG Exhibit 2C, which are the confidential pages of the direct testimony of Jessica York, IG Exhibit 3, which is the revised cross-answering testimony of Jessica York, IG Exhibit 4, which is the settlement testimony of Michael Gorman, IG Exhibit 5, which is the settlement testimony of Jessica York, IG Exhibit 6, which is the settlement rebuttal testimony of Michael Gorman, and IG Exhibit 7, which is the settlement rebuttal testimony of Jessica York.
Any objections?
No objection.
No objection.
No objection.
No objection.
No objection.
Hearing no objection, the industrial group's exhibits 1, 1C, 2, 2C, 3, 4, 5, 6, and 7 are now admitted into the record of this cause.
Thank you.
Mr. Haas.
Thank you, Your Honor. The OUCC moves for the entry of Public's Exhibit Number 1, public testimony of Michael Eckert as corrected. Public's Exhibit 1C, the confidential testimony of Michael Eckert as corrected. Public's Exhibit 1S, the settlement testimony of Michael Eckert. Public's Exhibit Number 2, public testimony of Brian Latham. Public's Exhibit 2C, confidential testimony of Brian Latham. Public's Exhibit Number 3, testimony of Caleb Lantrip. Public's Exhibit Number 4, public testimony of Brittany Baker. Public's Exhibit Number 4C, confidential testimony of Brittany Baker. Public's Exhibit Number 5, testimony of Jason Compton. Public's Exhibit Number 5S, the settlement testimony of Jason Compton. Public's Exhibit Number 6, testimony of Margaret Stull. Public's Exhibit Number 6S, settlement testimony of Margaret Stull. Public's Exhibit Number 7, public testimony of Cynthia Armstrong. Public's Exhibit 7C, confidential testimony of Cynthia Armstrong. Public's Exhibit Number 8, public testimony of Brian Wright. Public's Exhibit Number 8C, the confidential testimony of Brian Wright. Public's Exhibit 8S, settlement testimony of Brian Wright. Public's Exhibit 9, public testimony of Gregory Krieger. Public's Exhibit 9C, the confidential testimony of Gregory Krieger. Public's Exhibit 9S, public settlement testimony of Gregory Krieger. Public's Exhibit 9SC, the confidential settlement testimony of Gregory Krieger. Public's Exhibit number 10, public testimony of Sean Dellinger. Public's Exhibit number 10C, confidential testimony of Sean Dellinger. Public's Exhibit 10S, settlement testimony of Sean Dellinger. Public's Exhibit number 11, testimony of David Garrett. Public's Exhibit number 12, testimony of Dr. David Dismukes. Public's Exhibit number 12S, settlement testimony of Dr. David Dismukes. Public's Exhibit 13, testimony of April Peronish. Public's Exhibit 13S, settlement testimony of April Peronish. Public's Exhibit number 14, customer comments. Public's Exhibit 14S, supplemental customer comments. And Public's Cross-Exhibit 1, CEI DR response to OUCC DR 54.1 and 54.2. And Cross-Exhibit number 2, CEI DR response to OUCC DR 28.5.
Any objections?
No objection.
No objection.
No objection.
No objection.
No objection.
Hearing no objections, the following exhibits of the public are now admitted into the record of this cause. 1C, 1S, 2C, 3, 4C, 5S, 6S, 7C, 8C, 8S, 9C, 9S, 9SC, 10C, 10S, 11, 12, 12S, 13, 13S, 14, 14S, and cross exhibits 1 and 2. And now I'll turn it back to Ms. Close. Mr. Kyle.
We'll switch off here. The petitioner would call John D. Taylor.
Before you sit down, Mr. Taylor, I'll swear you in. You raise your right hand. Do you swear or affirm the evidence you'll give in this cause will be the truth, the whole truth, and nothing but the truth? I do. All right, you may be seated. Thank you. Mr. Kyle.
Good afternoon, Mr. Taylor. Can you state your name and business address for the court reporter, please?
John Taylor, 10 Hospital Center Commons, Suite 400, Hilton Head Island, South Carolina, 29926.
Mr. Taylor, on the table there in front of you are a number of documents that have been marked by the court reporter. I would like to go through those and have you identify them. First, can you find Petitioner's Exhibit 18?
Yes, I have it.
Does that consist of your prepared direct testimony and evidence in this proceeding?
It does.
You also have before you what's been marked as Petitioner's Exhibit 18C.
Yes, I have it.
Does that consist of the confidential attachment and work papers to your direct testimony?
Yes, it does.
Do you have before you what's been marked as Petitioner's Exhibit 18R?
I do.
Does that consist of your public rebuttal testimony, attachments, and work papers?
Yes, it does.
Do you also have what's been marked as Petitioner's Exhibit 18RC?
Yes, I have it.
Does that consist of the confidential excerpts from your rebuttal testimony, attachments, and work papers?
Yes, it does.
Do you have before you what's been marked as Petitioner's Exhibit 18S?
Yes, I do.
Is that your public settlement testimony, attachments, and work papers?
Yes, it is.
Do you have before you what's been marked as Petitioner's Exhibit 18SC?
Yes, I do.
Does that consist of the confidential attachments and work papers to your settlement testimony?
Yes.
And finally, do you have what's been marked as Petitioner's Exhibit 18SR?
Yes, I do.
Does that consist of your settlement rebuttal testimony?
Yes, it does.
All right, I'm going to read a list. Do the following or do you adopt the following as your sworn testimony and evidence in this proceeding? 18, 18C, 18R, 18RC, 18S, 18SC, and 18SR.
I do.
The petitioner would offer Petitioner's Exhibits 18, 18C, 18R, 18RC, 18S, 18SC, and 18SR.
Any objections?
No, Your Honor.
No, Your Honor.
No objection.
No, Your Honor.
No objection.
All right, hearing no objection. Petitioners Exhibits 18, 18C, 18R, 18RC, 18S, 18SC, and 18SR are now admitted into the record of this cause.
The witness is available for cross-examination, Your Honor.
Ms. Washburn.
Thank you. Good afternoon, Mr. Taylor.
Good afternoon.
We've been seeing you a lot more in Indiana.
Yes.
I have a few subject matters that I'd like to cross-examine you on. First, I'm going to aim to keep what we're going to discuss now public, and then we can move into confidential and highly confidential and camera sessions, which I'll try to minimize. But just so you know, we will start with public testimony. Please let me know if we start to dive into confidential and you think we need to go in camera.
All right, I'll do my best.
Okay, thank you. Your able counsel will let us know too, I'm sure. I'd like to first talk about production and transmission cost allocation. You provided testimony on that, is that correct?
Yes.
You're aware that there are lighting rate classes at issue in this case?
Yes, there are lighting rate classes.
Do the lighting rate classes benefit from access to the company's generation resources?
It all depends on how you define the term benefit. I mean, they use energy. They benefit from having the distribution grid and the availability of energy.
Okay. So do they use them to meet their demand during nighttime hours?
Yes, they use the energy to meet their requirements during the evening when they're on.
And so then late evening hours, early morning hours when the outdoor lighting is used, correct?
Yeah, that's the periods of time that are not coincident peak times for the utility. So when we're allocating the production assets, which is, I think, the line of questioning here, the lighting rates have a different contribution to the peak requirements of the utility, and thus they don't get a large portion, if any at all, of the allocation of fixed demand-related production cost.
Would you say that, so on that subject, would you say that they share access to the capacity of those resources with other customers?
They utilize those resources, but it's not cost causative. So the incremental capacity that's required isn't being required for CenterPoint based on the demands placed onto the system on off-peak hours by the lighting rate classes.
But they share access to the capacity of those resources with other customers, correct?
Yeah, they utilize these assets for energy, which is relied upon in the evening hours.
So their demands could not be served if those resources did not exist, correct?
Their demands would not be served if certain resources did not exist. The particular resources that CenterPoint has invested in for their production assets aren't being invested in for purposes of serving the lighting rate class, but those lighting rate classes utilize the existing stack of production resources for energy to turn on the lights in the evening.
So to summarize, when I asked could their demands be served if those resources did not exist, you said yes, but certain resources, correct?
Right. There'd have to be some type of resource out there in the utilities production stack at generating facilities that would provide energy to those lighting customers in the evening.
Did the 4CP allocator assign any generation cost to the lighting rate classes?
I'll have to look at that.
Okay. I do have a courtesy copy. May we go off the record so I can hand that out?
Yes, let's go off the record.
Thank you.
Found it.
All right, let's go back on the record.
Thank you.
Yeah, I can verify the question. The 4CP allocation factor does not allocate cost to either outdoor lighting or street lighting.
Thank you. Well, thank you. That made it very quick. Would you say you hold a master's degree in economics, correct?
Yes.
You understand the term free rider?
I think so. It depends on the context and the definition, so we'll give it a try.
Okay. Free rider, from the IURC's glossary, receiving benefits without paying costs associated with the production of those benefits, in parentheses, a subsidy. Are you aware of that term?
It's the first time I've heard that particular definition, but yeah, I generally agree with the definition of a free rider.
Okay. Are the lighting classes free riders on the company's generation resources under the 4CP?
Absolutely not. They pay for the energy that they're using. They're not setting the incremental requirements of the utility during the peak periods. And as I've demonstrated in my rebuttal testimony, the CenterPoint's resource adequacy is set by MISO. Those hours are still summer peaking hours, and the utility's incurring fixed production costs to meet those summer hours. And the 4CP allocation factor remains an appropriate methodology, both in this case and as found by the IURC in past cases. So there is no free riding of the lighting class related to production demand-related cost.
You previously, Your
Honor, can she allow him to finish his answer?
Mayor,
I just wanted to add that, in addition, I think it's important to recognize that the lighting class is paying for those energy and variable costs, which is a, indication that they're paying for the benefit or the use of those production resources. They're just paying those variable energy costs.
you previously testified that the 4CP allocator did not assign any generation costs to the lighting rate class.
Correct.
Would an energy-weighted methodology assign any generation costs to the lighting rate classes?
I think it would depend on how the energy-weighted methodology was derived, but in this proceeding in particular, the OUCC's and the CAC's proposed allocation, I believe, does allocate production-related fixed cost on an energy-weighted basis. And as I've demonstrated in my rebuttal testimony, I believe that's an incorrect approach and doesn't represent the cost-causative facts for CenterPoint. So yeah, depending on the particular energy-weighted method, there could be or would be an allocation to the lighting classes.
Thank you. Do the lighting classes benefit from access to the company's transmission system?
I believe so.
Could all of those lights be operated if the transmission system didn't exist?
I don't know that question. I haven't done an analysis to ascertain, if there's any production or generation assets that could serve the lighting class. Generally, the transmission system is bringing the production assets, energy, into a utility system and then dispersing that into the distribution network in which the lighting classes are attached. Yeah, in most cases, we can consider the transmission system, a part of the process or the infrastructure that brings energy to the lighting class.
Thank you. Under a 12 CP allocation regime, the outdoor lighting and street lighting classes are allocated a portion of costs, as we discussed before. Is that right?
Yeah, I think it might be around 1 basis point, so that'd be like 0.1%.
Yes, I have subject to check 0.12%, but it's there, correct?
Yes.
Do you know what the lighting class share is using a 4 CP allocator? We talked about 0, correct?
Right. Are you asking about on transmission?
So this, yes.
Yeah, if we apply the same 4 CP for the transmission as was done in the settlement, then yeah, the lighting class would also be 0% of the transmission cost.
And so just to summarize, under the settlement cost of service, the lighting classes are not assigned any production or transmission costs, correct?
Demand-related production cost would be the clarifier there.
Sure.
So they're not allocated demand-related production cost or transmission cost, which are all demand-related.
Thank you. You are generally aware with, or maybe quite aware in detail of FERC Order 1000.
I don't remember FERC Order 1000. I get all the FERC order numbers confused. Maybe you could refresh my memory on that one in particular.
So I have a excerpt. Would that be helpful to see?
Yes.
May I go off the record, Your Honor?
So let's go off the record.
Your Honor, while we're off the record, the council had emailed and advised the bench that it did not intend to remain for cross-examination. With the bench's permission, is the council excused from the remainder of the hearing?
Yes, you are, and thank you for the reminder. So I'll mention that when we go back on the record as well.
Thank you very much.
Sure. All right, let's go back on the record. And before you get started again, Ms. Washburn, Ms. Becker reminded me that the Common Council, we excuse the counsel for the Common Council of Evansville from the remainder of the hearing. Thank you. Ms. Washburn.
Thank you, Your Honor. You've been handed an excerpt of FERC Order 1000. Have you been able to review that?
I perused it pretty quickly.
Okay. The relevant text is from paragraph 622, referencing FERC's established principles of regional transmission cost allocation. Are you aware of that?
I see that, yes.
Okay. And you're generally aware of this regional cost allocation principle?
No, actually, it's the first time I've seen this that I can recall.
Okay. So you're not, you haven't read FERC Order 1000?
I may have in some other instance, but I didn't study it and don't recall it.
Okay, and so in terms of the principle, the line there, the cost of transmission facilities must be allocated to those within the transmission planning region that benefit from the facilities in a manner that is at least roughly commensurate with estimated benefits. You're not aware of this principle?
No, I can read that, yes.
Have you heard of this before?
Well, yeah, in the context of this proceeding, I think you would see in my direct testimony that we propose to allocate transmission on a 12 CP allocation factor, and I think that would be in alignment with this principle. But as you know, I think you've probably seen in the settlement, there is a concession related to the allocation of transmission facilities on a 4 CP, and there's also a concession related to the minimum system study related to the allocation and classification of distribution facilities. So, yeah, the initial proposal was a 12 CP allocation in alignment with how MISO allocates costs to their, is it the regional transmission, I'm forgetting the acronym. But anyways, how MISO allocates cost out to the various utilities.
Thank you. You can put that aside, please. I'd like to turn now to your settlement testimony at page 9, lines 6 through 7.
Yeah, I have that.
Here you talk about the cost-based backup transmission rate for BAMP service would be 22 cents per kilowatt day. Do you see that?
Yes.
And technically it's 0.22561, correct?
Yes.
And the settlement rate is about 95% of the cost-based rate, correct? Or if we add a couple decimal points, it's 94.51% by my calculation.
Yeah, the testimony reads 95%, so I think we're both on the target there.
Do you know, and if this requires a confidential response, if counsel and the witness and the bench could let me know, please. What is the value of that discount to BAMP customers in terms of dollars on an annual basis?
The value of a rate to a customer would be dependent on that customer. I have no clue what the value of this is to them. I don't know about their operations or their profit and loss statements or to what degree energy goes into their cost structure in general. So I can't speak to the value of any rate structure to a particular customer.
So you're not aware, Your Honor, could we go off the record for just a moment?
Sure, let's go off the record. We're good to stay regular?
Could we actually go in?
Okay,
for
oh,
just
we've got to go in camera, okay. So, I guess I have to be on the, yeah, let's go back on the record. So anyone, I guess, who is here who has not signed any kind of confidentiality with the parties will need to step out of the room. Does that apply to anyone? Anybody?
This is highly confidential.
Highly confidential? Okay. Okay. Anyone who hasn't signed off on highly confidential information, if you could just step into the hallway and then we'll come and grab you when we're done. Thank you.
Would that be you, Tabitha, as well?
Anybody else? Oh, okay. Let's go off the record for a second. He's going to grab him back. He's going to get it back. Anyways, okay, so it looks like we're all right then. Okay. All right, let's go back on the record. Okay, so we are going to go ahead and go in camera now. In camera, and our cameras are back on. Ms. Washburn.
Thank you, Your Honor.
Oh, also, while we took a slight pause, we are going to try to take a break at 3 o'clock. So just letting everyone know that.
Thank you. You were also handed or provided a white piece of paper that says CAC Exhibit 7, page 6.
I have that.
Great. This table, have you reviewed this from Mr. Barnes' testimony on the settlement?
Yes, I reviewed it in preparation of my settlement rebuttal.
And it does show that residential customers are allocated 4.552 percentage points more of the revenue requirement than CenterPoint's rebuttal position. Is that correct?
Yeah, on a percentage basis, it does, but you're comparing apples and oranges. It's $115 million under CEI rebuttal versus $80 million under the settlement. So it's not an informative percentage, but it does, that's the math.
And the settlement agreement results in large power service being allocated 16.92% of the total increase compared to 19.86% in the rebuttal position, which is that showing that minus 2.937% in the far right column.
Yes, that's what the table shows.
Thank you. Switching gears here, you can put that aside if you'd like. I'd like to discuss actually, I think those were my final questions for you, Mr. Taylor. Thank you.
All right. Ms. Schultz.
Your Honor, I had previously waived cross of Mr. Taylor, but in light of the CAC's cross, I would ask for the opportunity to ask a couple of clarifying questions.
It's fine.
Thank you. Good afternoon, Mr. Taylor.
Good afternoon.
You are aware that SABIC testimony was filed on behalf of Kyra Coyle, correct?
Yes.
Are you aware that SABIC took exception to CAC's allegation that the transmission allocation issues for BAMP customers was inappropriate?
Yes.
Are you aware and do you agree with the following statement from SABIC's witness? The settlement agreement establishes a commitment to evaluate a way to work towards rate parity for backup service customers that does not result in BAMP customers paying rates that are currently significantly higher than other CEI South transmission customers.
Your Honor, I'd like to impose an objection. This is friendly cross-examination. The parties are not adverse to each other. They are both sponsoring the settlement and are signatories to the settlement agreement.
Your Honor, my response is that we should be entitled to the extent that my client's testimony was challenged by cross-examination, I should have the opportunity to ask questions to clarify that.
Just for the narrow purpose of what you stated, that's fine, but we don't want to turn this into what she mentioned, a friendly cross. So you may proceed.
Thank you. Mr. Taylor, I'm sorry, that was a very long question. Would you like to have that read back?
That would be great.
Linda, could you read the question back?
I think I'll have to point to the settlement agreement in the section about what's intended, which is that CEI South agrees to evaluate the reasonableness of moving the backup service transmission rate toward parity with FERC Attachment O price and hold discussions with SABIC in advance of CEI South's next base rate case to determine the appropriate cost of service-based backup service transmission rate.
Thank you. I have no further questions.
Ms. Balzer.
Your Honor, if I may just very briefly go into camera to clarify, for highly confidential, to clarify the record on one.
Sure. Okay, so we're going to go in camera again, and I'm going to turn the cameras off. Wait. Oh. I just keep pressing the wrong button. There we go. Mr. Kyle.
No redirect, Your Honor.
All right, we need a moment, commission staff, so we're going to just go ahead and go off the record. And actually, I think we may just want to go ahead and, Linda, is it okay if we take our break now? All right, we're going to go ahead and just take a break because we may have some questions for you, but we need a little minute to discuss. So let's take a break and be back at 3 o'clock. So we are off the record. Thank you. Let's go back on the record. We have a couple questions for you, and I'm going to turn it over to Commissioner Valletta.
Thank you. We may need to go off the record for him to get Exhibit 18S, which is 18S attachment JDT S2. It's attached as Appendix B to the settlement. Do you have that, or?
I do have it.
Okay, great. If you can look at line 87 found on page 13.
Yeah, I'm there.
And there is a negative 92 for the RS column. Am I correct? That means the settlement proposed revenue requirement eliminates 92% of the RS class subsidies?
Yes, that's correct, as measured through this methodology. I was just looking at this yesterday, and the line 84 is representing the subsidy at a 4.23% ROR, and then line 85 would be representing that subsidy at the settled 6.77%. So I've always had a little bit of reservation with this measurement that often gets filed with the MFRs here in Indiana, because you're comparing two different levels of subsidies, one at a lower ROR to one at a higher ROR. But that is the correct interpretation, that there is this dollar decrease overall in the subsidy. So some of that is relative to the mitigation or the revenue targets, and some of it represents just the fact that you're going from a 4% to a 6.7%.
Do you recall what the class subsidy reduction approved in CEI South's last rate case was?
I do not recall.
Thank you. We don't have any further questions.
All right, thank you, Mr. Taylor. You're excused. Let's go off the record. Linda, you ready? Everybody ready to go? Are you ready? All right, let's go back on the record. Ms. Close.
Thank you, Your Honor. Petitioner calls Richard C. Leger.
Before you sit down again, can you raise your right hand? Do you swear or affirm the evidence you'll give in this cause will be the truth, the whole truth, and nothing but the truth? Yes, ma'am. All right, thank you. You may be seated. Ms. Close.
Good afternoon, Mr. Leger.
Good afternoon.
And you'll tell me if I'm mispronouncing your name, right?
I probably would not.
Well, if you could, state your name and business address for the record.
Sure. My name is Richard C. Leger, and my business address is 211 Northwest Riverside Drive, Evansville, Indiana, 47708.
And by whom are you employed and in what capacity?
I'm employed by CenterPoint Energy, and my title is Interim Senior Vice President, Natural Gas Business.
And you should have before you what's been marked for the purposes of this hearing as Petitioner's Exhibit number 1. Have you found that?
Yes, I have.
Does that consist of your prepared direct testimony in this cause?
Yes, it does.
Do you have any corrections to your direct testimony?
Yes, I do. I have a correction on page 1 of 17, and that's at line 11 and 12, where it's asked what my role is. And since this case has been filed, I have changed roles, and I'm now the interim senior vice president of natural gas business.
And can you mark that change in the court reporter copy and initial in the margin once you've done so?
Yes, I have.
Would that change also apply to the cover sheet on Petitioner's Exhibit Number 1?
Yes, it would.
Can you mark that on that cover sheet and initial, please?
Absolutely.
You should also have in front of you what's been marked as Petitioner's Exhibit Number 1R. Have you found that?
Yes, I have.
Does that consist of your prepared rebuttal testimony in this proceeding?
That is correct.
Do you have any corrections to your rebuttal testimony?
Yes, I have the same correction to make on the cover page, which is interim senior vice president, natural gas business. And then also on page 1 of 8, line 11 and 12, where it states, I am senior vice president of Indiana Electric. That needs to be changed to interim senior vice president, natural gas business.
Can you mark those changes and initial in the margin for me?
Yes, I can.
With those corrections, Mr. Leger, do you adopt what's been marked as Petitioner's Exhibit Number 1 and Petitioner's Exhibit Number 1R as your sworn testimony and evidence in this proceeding?
Yes, ma'am.
Petitioner would offer Petitioner's Exhibit Number 1 and 1R.
Any objections?
No, Your Honor.
No objection.
No objection.
No objection.
Hearing no objection, Petitioner's Exhibits 1 and 1R are now admitted into the record of this cause.
Thank you, Your Honor. The witness is now available for cross-examination.
Ms. Washburn.
Thank you. Hi, Mr. Leger. How are you?
Doing well, and yourself, Ms. Washburn?
I'm all right. Congratulations on the promotion.
Thank you very much.
I have several items that I'd like to discuss with you in your direct and rebuttal, please.
Yes, ma'am.
As an initial matter, you attended the field hearing, correct?
That is correct, I did.
And do you recall the first speaker being the Evansville mayor
Yes, I do recall.
and the second speaker being her Republican opponent who had lost the race but also spoke in opposition?
Yes, I do remember her.
Was that your first field hearing to attend?
No, it was not.
Do you ever recall seeing a crowd that size for a field hearing?
Not to my knowledge, no.
I'd like to move to what has been marked as CAC CX3, please. Thank you, Ms. Rubel.
Let's go off the record.
Yes.
What is CX3? Which document is that?
I apologize. During our break, I handed out several cross exhibits.
Okay.
I can walk through and just so everybody has them straight.
Okay. I don't know if we have.
Oh, I apologize. Did I hand them up there? Okay. Sorry. Could we go off the record, please?
We're still off, yeah.
Okay, thank you.
It's not the data request response, is it? Okay.
Oh. Thank you. Yes, ma'am, I'll do that.
Let's go back on the record.
Thank you. Apologies for that. As an initial matter, the original requested increase was $47 a month for residential customers, correct?
That is correct.
And with the settlement, it is $35 a month, correct?
That is correct.
And times 12, that's approximately $420 a year.
Yes.
Thank you. Moving to what's been marked as CAC CX3. This shows for each of the calendar years, 2018, 2019, 2020, 2021, and 22, the amount in dividends that CEI South paid to its parent company. Do you see that?
Yes, I do see that.
And its parent company being CenterPoint based in Texas, correct?
That is correct.
And so the acquisition of CenterPoint occurred in 2019, correct?
You referring to the acquisition of Vectron?
Yes.
Yes, that is correct.
Okay. So in 2018, it was $57 million, 2019, $0, 2020, $69 million, 2021, $30 million, and 2022, $37 million. Do you see that?
That is correct. Yes, I do see that.
So that's all money that is going from Indiana to Texas, correct?
I believe that goes to the overall corporation, yes. To say that it just goes to Texas is incorrect.
Okay. But it goes to the parent company leaving CEI South.
That is correct, yes.
Moving to what's been marked as CAC CX4. And I have the complete copy, if you would like that, of the CenterPoint annual shareholder meeting document. You've seen this?
I have seen this, yes.
And on page 56, which is what's the excerpt that you've been provided with CAC CX4 through 58, so pages 1 through 3 of the cross exhibit, this shows the executive compensation tables, correct?
Yes, that is correct.
And it's your understanding that Mr. David, how do you say his last name?
I believe that is Mr. Lazar.
Lazar, $16 million in 2023, is that correct?
Yes, I believe so.
And besides 2019, are you aware of another time when CenterPoint did not pay dividends to shareholders?
Yes, the overall parent company in 2020, well, I'm sorry, let me rephrase that. I can't remember of a time that CenterPoint Energy did not pay a dividend to its shareholders. What I do recall is twice in my career that we have lowered that dividend. I can't remember when the first time it was early on in my career. I will say the second time was in 2020 when we lowered our dividend, and today the dividends that we pay is still lower than pre-2020.
Okay, thank you. You speak a lot to affordability in your testimony, correct?
I do. I dedicate quite a bit of time to it, yes.
In the 7.5 pages of your double-spaced rebuttal, are you aware that you say 43 times affordable, unaffordable, some derivative of afford in your testimony?
I did not make that count, but I trust that you did.
I did, a couple times. So let's walk through your rebuttal testimony a bit, please. You state at page 1, line 23, that all of your comments tie back to affordability. Is that right?
That is correct.
And you are responding, lines 19 through 21, you're responding to comments from the public field hearing, correct?
Which page are you on again? I'm sorry.
Page 1.
Page 1 and comments, sorry, 19 through 21?
Yes, you talk about your rebuttals responding to OUCC, CAC, and comments from the public field hearing, correct?
Yes, that is correct.
So your rebuttal testimony was filed April 9th, which is before the settlement was reached, correct?
That is correct, yes.
And in rebuttal, Centerpoint, in response to consumer parties and the field hearings, shaved off a couple million. Is that about right?
Yes, that is correct.
And then in settlement, we're able to find more millions to concede on, correct?
Yes, I believe we reduced our ask roughly $38 million from the original filed position, which is closer to OUCC's rebuttal position than our originally filed position.
And in this rebuttal, on page 2, lines 10 and 11, you say, "We listened carefully and understand the public sentiment presented." Could you expand on that, please?
Yes, I attended the entire hearing and listened to our customers' testimony and understood the concerns and the sentiment of the hearing.
And the next sentence, "A common theme emerged around affordability or lack thereof as it relates to their utility bills." You see that?
Yes, that is correct.
And so in response and rebuttal, Centerpoint only lowered a couple $1 million, right?
I agree that in our rebuttal testimony, we only lowered a couple $1 million. However, if you look at the settlement, which is in the interest of all customers, it was lowered $35 million from our roughly our rebuttal testimony and 38 from our original filed position. And I'd also like to remind you, Ms. Washburn, if you look at my original testimony, we, before we even filed the case, understood that affordability was going to be a concern. And if you look at my testimony, we reduced our ask ahead of filing the case. I would be hard-pressed to know of any other utilities that reduced their revenue requirement and reduced their expenses ahead of filing a rate case.
You're aware that we have utilities all the time say, here's a range of an ROE, and we picked the lower range, right?
Yes, I am aware.
But typically the lower range from the utilities perspective, it's always in the 10% range, right?
I agree. It's in the lower range of the 10% as far as in our filed position. However, there are other positions that we took in there that lowered the revenue requirement. Additionally, if you remember securitization, we fought for securitization in the legislature, and then we are the only utility right now that are taking advantage of securitization, and that has produced net benefits to our customers of $53 million. So again, another point ahead of our rate case to try to lower the effect on our customers.
Have you heard the consumer advocate theory that our utilities typically ask for double what they need so they can position themselves for settlement?
I can't say that I've heard of that. What I would tell you is what we file for is a math equation, and it's meaning what is your cost of service, and then your and the rates that are associated with that. To say how all that math is calculated, I would defer to other witnesses in the case.
Mr. Inskeep in testimony has several suggestions of what the commission could do to try and address affordability. You read Mr. Inskeep's direct testimony?
I did read his direct testimony, yes.
One was to order a management audit of CenterPoint to identify additional efficiencies and opportunities to reduce costs, examine leadership decision-making processes and incentives, and identify reforms to ensure ratepayer affordability and appropriately prioritized by management and incorporate into decisions. Does that ring a bell?
That rings a bell, and I believe we addressed that with direct testimony from witness Rice.
Is this, as the senior leadership in the case here, is that something CenterPoint would agree to?
No, that is not something we would agree to.
So additional efficiencies, you don't think there's any other places to trim the fat?
What I'd say is we work on a regular basis to run our utility as efficiently as we possibly can.
Do you involve stakeholders in attempting to identify efficiencies to reduce costs?
Yeah, I believe our IRP is very heavily attended by stakeholders, both your organization as well as OUCC, as well as individual public folks, and we work together and provide a solution based on that.
What about the operations, compensation, other items like that? That's not part of the IRP process, correct?
No, the compensation and witness Williford would be the correct witness to go deep into that, but what we do is we deploy a market base, and so we look at similar job codes across utilities, and that's how our compensation is calculated.
At the field hearing, you recall you heard testimony about individuals and families who were facing eviction due to unpaid utility bills. Do you recall that testimony?
I recall the testimony, yes.
And in fact, one of the charitable organizations identified in Mr. Olson's testimony, noted that the amount of evictions that they encounter because of utility bills, unpaid utility bills. Do you recall that?
Actually, I don't recall that. I know that there were some cases at the field hearing are brought up about bills, and witness Rice, if you go to his testimony, he does a full-on bill analysis based on what our total average bills are in that field hearing.
Yes. What would you say to customers who can't afford current bills and now are being asked to provide an additional $420 a year to CenterPoint when they're comparing that to the executive compensation of CenterPoint?
We certainly empathize with customers that have challenges. That being said, we do take every measure necessary to work with our customers on offering bill assistance programs and such. And then, yes.
You talk about payment plans and budget billing in your testimony. Is that one of your examples?
That is correct, one of our examples.
And those are required by Indiana code, correct?
Those are required by Indiana code, but I know that they're to offer them, but I would say that we go through great lengths to work with our customers. We even extend the payment plans beyond what's out there. We do everything that we possibly can to work with our customers.
But you haven't offered a bill assistance program, correct?
Currently, we do not, but if you do remember, if you read my testimony, that we talked about Share the Warmth program, and we are currently working to convert the Share the Warmth program from a weatherization program to a bill assistance.
Yes, let's talk about that, please. If you could look at what's been marked as CAC CX 6, 7, and 8.
It's quite a few pages. If I'm to read it all, I will need to take some time, if that's okay.
Sure. I can walk you through where we're going to be looking, but if you prefer to take the time, we can do that too.
Tell you what, let's do both. Why don't I read it, and then you can walk me through where we're
Okay.
going to go through there, if that's
Fair.
okay.
Thank you.
Let's go off the record. You can just let us know when you're ready to go back on the record.
Okay, I've reviewed.
Let's go back on the record.
So you testify, again, filed in your rebuttal testimony on April 9th, 2024, that the Share the Warmth agents, the entities administering the Share the Warmth funds did not spend the money that was allocated. Is that your testimony?
Yes, that was my testimony.
What year were you talking about?
I can't speak to the specific year. I know that I asked the person that that runs this program about our funds, and they had stated that they have not spent all of the money.
Let's look
At one point in time, too, I was involved with Share the Warmth program, and I can say that when I was involved, and this is dated, but it was in 2021, 2020, and 2019, those agencies did struggle to spend those dollars.
You're aware that CAC works frequently with the Indiana Community Action Association and the community action programs?
I'm aware, yes.
And so it's your credit and risk department that administers or provides the funding of the Share the Warmth, correct?
That is correct.
Looking on page 7 of CAC CX6.
Which page again?
Page 7.
Okay.
So as an initial matter, you're aware the program typically runs from the fall to the spring, correct?
Yes, that's correct.
And so this email here from the administrator at Indiana Community Action Association provides the 2022-2023 figures and end-of-the-year report to an April Vaught, V-O-G-T, and Teresa Colum at Centerpoint. Do you see that?
Yes, that's correct.
And there it notes, all monies have been spent. Do you see that on the, after good morning, we have wrapped up the Share the Warmth program for the 2022 to 2023 program year. All monies have been spent. Do you see that?
I do see that. However, what I don't see is a full statement of cash flows. What we've seen in the past is, okay, you have that. What I don't see in the past is, what I don't see is that in the past, they would not spend them and then we would give them permission to exceed the program year, and then those monies would roll over into the other year. So all I can see is the 2022-2023 program here from these particular.
Yes. And it does say they spent the money, right?
For 22-23, yes.
Mm-hmm. And let's see, down to the third paragraph, starting with, I have agencies already asking for more Share the Warmth funds. Will there be a new program for the 2023 to 2024 program year? Having this program over the past 16 years has been a tremendous help to your customers / our clients throughout the state of Indiana. Do you see that?
I do see that, yes.
Do you know, did Centerpoint provide a program, any Share the Warmth money at all for the 2023 to 2024 program year?
Your Honor, I'd like to object. I think the question assumes facts that are not in evidence.
I'm just asking if he knows.
I'm going to overrule that objection.
Can you restate the question?
Sure. Was there a program for the 2023 to 2024 program year? Any money provided by Centerpoint?
I'm not sure. I can't answer that.
Moving, so let's see. So moving to page 5 of 8 After Ms. South inquired again, not receiving a response between May and September 2023, Ms. Vaught responds in September 6, 2023, there is money that we'll be sending out. I just need to get a moment to get it taken care of. Do you see that?
I do, yes.
And then again in April of 2024, Ms. South reached out asking if there are any funds available for that year. Do you see that?
Yes, I do.
And going to the very first page of this cross exhibit. I asked Ms. South to compile the money that CenterPoint and formerly Vectren provided over the years. And that is what's starting there on page 1. If you turn to page 2, you'll see a table. Do you see that?
Yes, I do.
And so it ranges from 2007 to 2022. Do you see that?
Yes, I do.
And CenterPoint acquired Vectren in 2019, right?
Yes, we did.
So between 2019, it dropped from $348,400 to 2020 down to $286,000.
Your Honor, I'm again going to object. I think the question is assuming facts, not an evidence. There's not been a foundation laid for any of the information that Ms. Washburn is premising her question upon.
Are you going to lay a foundation for this?
I'm going to establish this. I can keep asking some questions and come back to that question if that would be helpful.
Sure, that's fine.
Okay. So in preparing your statement and rebuttal, you're not aware of which year you were referencing?
I directly asked the program providers if they had been spending the dollars, and they said they had continued to roll dollars from year over year to them.
And if you could turn to CAC CX8.
Okay?
Have you seen this document?
I don't believe that I have, no.
So you didn't look to see the documentation to back up your statement that whether or not the funds were spent in 22-23?
I have not seen this document.
And in fact, you didn't check to see if Inca responded to that letter, did you?
No, I did not.
And you're not aware if CenterPoint provided any money for the 2023 to 2024 year, correct?
I am not at this point, no.
And has CenterPoint committed to providing 2024 to 2025 funds?
I can't answer that. I don't know. I'm not affiliated with Share the Warmth at the moment as far as I'm sorry, not affiliated. Sorry, I'm not on the Share the Warmth board any longer.
So you're not aware whether or not all of the funds were spent in 2022 to 23 as Ms. South's emails indicate that it was?
I can't answer to what Ms. South's emails claim. I can only answer to what our internal staff had spoken to.
And do you know any of the dollar figures that were purportedly provided year by year?
I don't know that off the top of my head. No, I do not.
Looking at CAC CX6, page 2, that table, do those look familiar?
Yes, they look familiar.
And so there has been a $125,000 drop between 21 and 22.
Yes, that is correct. And that, subject to check, though, that could also be that backlog of funds that they did not spend.
But you're not sure that they didn't spend the money?
I'm not sure, no.
Right. As the most senior person testifying here today, if the community action programs are saying they're using the money for weatherization and would prefer the money to stay in weatherization rather than bill assistance, would you agree to that?
I would not at this point in time, because I think there are other funds available in the market, whether it be federal weatherization funds. There's also weatherization programs that's associated with our energy efficiency funds. We partner with the J.D. Sheath Foundation in Evansville on weatherization. And so there are a lot of weatherization funds in the market. And I believe one of the y'all's asks in the case was that we provide a bill assistance program. And so that is one of the things that we are working to do, which is provide a bill assistance program at through the Share the Warmth Foundation. And might I add, we plan to fund that with shareholder dollars.
Well, you're talking about crisis funding, not monthly bill assistance, right?
That's correct, yes.
And
it would be supplemental bill assistance, and what I might would add is it's to the ALICE population. I'm not sure if you guys are aware with ALICE, Asset Limited Income Constrained Employed, and many times though that group of customers don't qualify for different funds such as LIHEAP and different things. And so what we're trying to do is provide a fund that is gap funding for that particular customer base.
when CenterPoint shareholders provide crisis funding to customers, where does the money go?
Goes to those customers.
It goes back to the company, right?
Yes, it goes to help pay them their bills, yes.
What about weatherization? How is that different than crisis bill assistance?
I guess the weatherization funds, not guess, the weatherization funds go to weatherization activities such as insulation and caulking and things like that to help weatherize the customers' homes.
And in fact,
we're not against that. In fact, we provide energy efficiency funds for that. We've partnered with J.D. Sheath Foundation in that, and then there's also other funds that are out there. We're trying to offer additional funds for, go ahead, sorry.
how much money was with the J.D. Sheath?
I can't answer that off the top of my head. I believe Witness Rice has some of that information in his testimony and can answer that directly.
And again, you have several CAP agencies, not least of which CAPE, there in Evansville, who have used every single dollar, at least according to Ms. South, that has been allocated to them. Are you are opposed to talking to the community action programs to see if they want to keep the money for weatherization?
I think we're always open to a discussion. However, we have made a policy decision which is in the full right of the Share the Warmth program that is a separate organization to do that.
I'm sorry. Can you clarify what you're saying there?
Yeah, Share the Warmth is it's a separate 501c3, I believe, that is part of. It's not a. It sets on its own, has a board of directors, and has a group that governs that. So
And what's CenterPoint's involvement?
We run it. Our board is our employees that direct the funds. Yeah.
And so if CenterPoint wanted to keep the funding, if they wanted to raise the funding to historical levels, they could, right?
They could, yes.
And they could perhaps use the dividend money leaving Indiana to go to the parent company, right?
We already use shareholder funding to fund it, and we and again, in the switching to a bill assistance program, we would use shareholder funds to fund those dollars. And one of the things, I'm not sure that you are aware, but if you go to the originals articles of incorporation on that particular fund, it was originally set up as a bill assistance program, and then it was converted to a weatherization program, and then we're working to convert it back to bill assistance.
Why was it converted to weatherization?
I can't answer that. That was well before my time.
Was it perhaps conversations with the CAPs?
I'm not sure if it was conversations before the caps, or maybe they didn't. There wasn't weatherization funding in the market at that particular time from the energy efficiency funds. Any of those things that I would say would be pure speculation, and I just can't. I wasn't there.
Can you commit to reaching out to your caps to find out what they need?
I could commit to reaching out to the caps to certainly figure out this particular issue and the funding. Yes.
Thank you. Moving to what's been marked as CAC CX5, please.
Yes, I'm there.
You have a rate that you note. Well, let me back up for a minute. In your testimony, you say on in rebuttal, page 2, lines 13 and 14.
Yes.
Can affordability be easily addressed? Answer: in a utopian world, affordability would be easily addressed. Did you write that?
Yes, and what I would say is I do regret my term of the word utopian. However, if you go on to read the rest of that Q&A, it says affordability is a complicated matter that crosses all socioeconomic factors and means many things to many different people. Additionally, affordability spans many other factors that include health, food, environment, cost of living, and many other drivers that include customer choices. And yes, utilities are certainly a driver in affordability. We do not take that for granted. I say all of this to acknowledge that affordability is difficult, and I will attempt to directly respond to affordability arguments raised in this case by our customers and interveners. And again, if I had a time machine and could go back, I would erase that first statement, and I would start that with affordability because the sentiment is still correct.
Could one affordability measure be lowering the ROE further from 9.8 perhaps to 9.2%, which would provide another $10.8 million in annual reduction?
I think what we provided in the settlement testimony is a fair settlement. And if you look at 9.8, that is consistent with other settled cases, including our own other utilities in the state. Additionally, I just recently reviewed a settlement, an order in Mississippi for one of our other utilities that's a calculated ROE, and it's based on recently settled cases across the United States. I can't, and in that we received an ROE of 10.3%. I don't say that to say that that's what we're requesting in this particular case. I say that to say that ROEs are actually driving north across the United States. They're going larger, and we are filed a 9.8%, which is consistent with other utilities in Indiana.
This is your own only investor-owned electric monopoly utility here in Indiana, correct?
It is our own yes, our only one in Indiana, correct.
And is it your only monopoly utility in your parent company?
We have 2 gas utilities in Indiana. We have a gas utility in Ohio. We have a gas utility in Minnesota. We have both a gas and an electric utility in Texas. And currently we have a gas utility in Mississippi and 2 gas utilities in the state of Louisiana.
Are gas utilities different than electric in terms of?
They are, yes.
Would you say that, would you agree with me that CenterPoint has some unique challenges in the state?
Yes, I would say that they do.
And in fact, CenterPoint ranked 16 out of 16 on the J.D. Power rankings for customer service, correct?
Yes, we are certainly not happy with that ranking. As part of that, one of the things that we have recently done because of that is we've developed a cross-functional team to start working on how do we improve our J.D. Power score in that. I would say one of the things that is unique to us here is that we have a combined bill. So you have both a gas and electric bill, and I believe that has an effect on the J.D. Power score.
So you take issue with the J.D. Power independent rankings?
I don't take issue with the independent rankings. I do take issue that we are last, and I do take it personally. And I don't mean it from that I disagree with them. I mean it in that we can do better.
You're aware that for 16 years, CenterPoint has had the highest bills for electric utilities in the state?
I think that's not completely accurate. I believe that there some other utilities have recently gone higher than we are.
Notwithstanding the 2024 report, but prior years, is that correct?
Say that again, sorry.
Notwithstanding the recently released IURC residential bill survey.
Yes, that's correct.
Okay. Does Evansville face unique challenges in terms of income levels?
I don't know that it's unique. I know that the average income, based on what's in Witness Rice's rebuttal testimony, is that those incomes are rising on average, and on average they have risen higher than what our rates have risen.
Didn't CenterPoint partner with the city of Evansville to go after some federal funding strictly on the basis of the poverty statistics in Evansville?
I'm not sure.
If you could turn to your rebuttal on page 4, line 27.
Yes, I'm there.
It states you downloaded the affordability data that's posted on the OUCC's website and found that CenterPoint disconnected 0.35% of our residential customers over the 16 months of data provided. Do you see that?
Yes, that's correct.
If you could look at CAC CX5.
Yes, I'm looking at it now.
So this is the spreadsheet that you looked at.
Yes.
And notwithstanding, there's a box at the bottom where we did our own calculations here.
Yes, and I disagree with that calculation. I think it's
Why?
incorrect. Oh, I'm sorry. That's actually a good tip as a witness. I should pause for my attorneys to have a opportunity to speak. So yes, I do disagree with that calculation because what you're doing is you're taking the total number of disconnects over I believe this is I'm going from memory, but I believe this is a 16-month calculation, and then you're only applying that total number of disconnects over 16 months. It could be different customers, it could be similar customers, to the total number of accounts. The way we do it is we look at number of bills, and so I made that calculation of adding up the total number of disconnects over the 16 months plus the total number of bills over the 16 months, and that's how you get the calculation. I did the same calculation for other utilities in the state using this bill survey, and that's how I came up with that calculation. So I do disagree with this particular exhibit, yes.
The number of bills, where are you talking about? Where is that in the?
So that's if you look at the number of bills rendered. So if we have 131,780 electric customers, that's 131,780 electric bills. So if you want to do an apples to apples comparison, you would look at the disconnect of 203 and you would divide 131,000 into 780. I'm looking at that first line there. And that's how you would get that percentage. And that's how I calculated that number. I'm so sorry. I apologize.
Yeah, could you go over that again for me, please?
Okay, yes. So for you to do this calculation correctly, if you were going to add up the total number of disconnects over the 16-month period, you would also need to divide the total number of bills. So the total number of bills would be the number of monthly customers and the number of bills that are associated with those customers. If you were to look at it on a month-to-month basis, you would take, again, for instance, let me put my glasses on. These are small numbers. 263 disconnects in the 9th month, and you divide 131,780 into that because that's the number of bills that were rendered in that month.
So we were looking at number of customers and you were looking at number of bills.
That's correct, yes.
Okay. So
And you can do it your way, but you have to do it on a month-to-month basis that way. You're kind of, I can't think of the right term. It's an incorrect calculation.
What would be an acceptable number of disconnects for you?
I can't answer what an acceptable number of disconnects are. What I would say is that anytime we disconnect a customer, we do so after having done everything that we possibly can to work with them.
What does that mean?
Point back to my testimony where we have offered bill assistance. I'm sorry, not bill assistance. Where we have offered, we would like to offer bill assistance. Where we have offered to connect customers with different agencies. We have offered to extend payment plans. We have offered to move their date around for due dates. We've provided access to service fairs to connect customers with different agencies and different utilities. We are working with our customers.
Yeah, the service fairs, we reached out to partners in Evansville, and this was just a handful of different meetings, 6 or 7 different meetings, correct?
Actually, I would call them more than meetings. What the access to service fairs are is we worked with the city of Evansville, and we secured a location. We brought in our utility and customer service agents. We also brought in their utility with customer service agents. And then we brought in local agencies that provide bill assistance. And I believe there were some other services that were brought along. I think our weatherization team was there with our energy efficiency team. And we offered the ability for customers to come and speak with us directly and get help on their bills. So to call it a meeting, I think, is a gross mischaracterization. I believe it's a good attempt to work with our customers.
Yes, I should have said events. So the mayor of Evansville hosted 6 access to service fair events, and you were requested to attend, right?
Actually, no. We worked together with the mayor's office to provide those, and we have also been the driver of continuing those. The first one, I wish I could remember when the first one was. I really can't. But that was, we worked with the mayor's office in conjunction and provided them. And then going forward, we were actually the driver of continuing those.
So you did not, though, offer any actual bill assistance, just options for payment arrangements and budget billing and pointing them to your weatherization programs, right?
That is correct, because we don't have any bill assistance programs at this time.
Are you aware Evansville Water offered $5 off at all of these events if they came to speak to them?
Yes, I believe, you know what, I'd be speculating as to how they did that. I'm sorry, but I go ahead, sorry. Yes.
Well, you're kind of pausing. I just wanted to check in and see if you know how much time you have left.
If we could take a 5-minute break, I think I'm very close.
All right, let's go off the record and take 5 minutes, be back at 4:15. Thanks. Yep, thank you.
Thank you, Mr. Leger. Just a couple more questions. In your calculation of your, what I understand to be more of a monthly calculation of the disconnects, is that right?
That's correct, yes.
Okay. And CAC's calculation is more of a yearly one that might have people who are disconnected more than once, right?
Yes, I would agree to that, yes. What I would also say is, if, subject to check, I did the math for Duke, I&M, and what are some of the other, anyway, some of the other electric utilities, and they were all very similar. We were all either inline. So if you take Mr. Inskeep's, or CAC's, I'm assuming this was Mr. Inskeep's data, and you kept it proportional, it would still hold the same. It would render a different percentage, but the proportion would be roughly the same, subject to check.
But we don't have that.
I did not calculate it the way Mr. Inskeep did, so I would have to go back and look at that.
Okay. And we don't have the other utilities disconnect numbers in the record, right?
It's not in the record, no.
Okay. Did you go back to see if disconnects are increasing year over year for CenterPoint?
I did not know.
With regard to reliability indices, you review those?
Yes.
And you understand that CenterPoint has had worsening reliability over the most recent 5-year period?
One of the things to think about in those numbers is there's some noise in there, right? So we've had, I would think everyone would agree that increasingly challenging weather over the last few years. I don't remember a time of going through where there's 8 tornadoes come through a service territory at one time, and then also recently had another tornado. Then we had the storm of the Ring of Fire that kept regenerating itself. That being said, if you look at some data in Mr. Rollinson's chart, there are 2 things. There's reliability and there's resiliency. And you look at the reliability, which would indicate equipment failure, and you could see that SAIDI minutes associated with equipment failure are going down, which would indicate a much more reliable grid. And if you look at, if you think about resiliency, which are which are included in investments that we make into the system, we certainly would not, after having a tornado run through the area that took out 35,000 customers, which is roughly, I can't do that math in my head, but it's a significant amount for our customer base, and have them back on in 3 days.
So the analyses that CAC provided excluded major event days. You're aware of that?
I am aware of that, yes.
Okay, so that would exclude big storms.
It would exclude big storms, but there are still weather that's involved in that. There's also things such as cars hitting utility poles and taking out. I remember recently we had one where a car took out a transmission pole, which was significant.
What would make CenterPoint unique in that regard? Aren't all utilities facing those types of issues?
I would agree that we do all face those types of issues. What I would say is, from a resiliency calculation, if you look at how quickly we restore our customers, and I'll take I'm going back in time of when we had, it was a couple years or a year ago when we had the storm that, again, we called it the Ring of Fire. It just kept regenerating itself, right? And that affected all utilities across Indiana. And I looked at our restoration rates, how quickly we got customers back on. And we continually exceeded other utilities from a percentage basis on our restoration, which would indicate a much more resilient grid.
But you do agree that the Sadie, Katie, Safey figures have been getting worse over time?
I don't agree, no.
You don't agree with that?
I agree the numbers are getting worse, but
Okay,
I
thank you.
believe the reliability of our system and resiliency of our system continues to get better.
At this time, Your Honor, I would move to admit what's been marked as CAC CX3, CAC CX4, CAC CX5, CAC CX6, 7, and 8.
Petitioner.
Your Honor, we have a couple of objections. We do not object to CAC CX3 or 4. We do object to CAC CX5. I believe that when Ms. Washburn attempted to lay the foundation for this document, she referred Mr. Leger to what he had reviewed. He did not identify the bottom half of this document. And with respect to CAC 6, again, I don't believe that Ms. Washburn has laid a foundation. She did not ask the witness if he was familiar with this document, if he knew what it was. It's not been properly authenticated. CAC CX7, I don't recall any of Ms. Washburn's questions even touching on or her mentioning. CAC CX8, again, I believe when the witness was asked, he could not identify this and had indicated he had not seen this document.
Can you repeat what you said about 5? I'm sorry.
Yes. On 5, the witness was unable to identify the bottom half of this document. That is the calculation that was added to this table by the CAC.
Ms. Washburn.
Thank you. With regard to CAC CX5, we walked through at length the calculations here and had a robust discussion on the differences between what Mr. Leger had in his rebuttal testimony versus the yearly calculation that we provided here. It's a simple math formula here that shows how it is derived. If the witness would like to have a calculator, this is information downloaded from the OUCC's website that CenterPoint provided itself. Should I move on to the next one? Okay. CAC CX6 is the share the warmth information that we got from the main contact of the recipient of the funds. It has CenterPoint employees on here, has the dates, it has the relevant information. We walked through and Mr. Leger agreed that on page 2 of the document, these figures looked right in terms of what CenterPoint/Vectren has provided in years past for shareholder funds. We are trying to get to the truth of the matter of what's actually going on with the Share the Warmth Fund, and this document aims to do that. It's an authenticated document in the sense that it has all of the email information. Nothing has been altered. It is directly from the source. CAC CX7, this is the cover document that provided the letter that Share the Warmth provided, asking for the money back. That is an issue that we discussed as well. Again, this is from CenterPoint and shows the email thread here between the credit supervisor, Jared Wells, and the recipient of the Share the Warmth Fund, who then distributes it to the community action programs. And then the CAC CX8, I believe that Mr. Leger authenticated this document, said that he understood, and this was the document that was formalizing his understanding that Share the Warmth Act asked for the money back for the 2022-2023 year.
Just a moment.
Thank you.
All right, I think we're going to overrule the objection and admit all of the cross exhibits over petitioner's objections. So CAC cross exhibits 3, 4, 5, 6, 7, and 8 are now admitted into the record of this cause.
Thank you, Your Honor. Thank you, Mr. Leger. I have no further question.
All right, so I think, so the OUC, Ms. Schultz, you don't have any, right?
I do not, Your Honor.
And Ms. Balzer?
No questions, Your Honor.
Okay, so the OUCC has represented that it has about a half an hour, 45 minutes-ish of cross from Mr. Leger. Since it's late in the day now, I think we are going to, in a moment, take a break for the day, and then we will continue with the rest of Mr. Leger's cross, any redirect, and then Mr. Rice. Tomorrow, we are able to start at 10 a.m. if that works for everyone. I think we had said maybe had said 10:30 before, but 10 a.m. we should be able to start at 10. Does that work for everyone?
Yes, Your Honor.
Yes, Your Honor.
Okay. And it's also our understanding that there's about a half an hour from CAC and OUCC on Mr. Rice. Is that about right?
Yes, I technically said definitely less than an hour.
Okay.
But
Okay. Less than an hour. Okay.
hopefully, yes.
All right. So we will, let's go off the record, or sorry, we'll continue the hearing until tomorrow at 10 a.m. and then now let's go off the record. And thank you, everyone.
Thank you.
Thank you.